Hi everyone. In today's video, we are going to be looking at how to ascertain who the key parties or the key players are in a contract law question. Now, this video is aimed at students who are unfamiliar with law subjects or contract law. So if you are a second or third year law student, most of this will be far too easy for you. So this video is really designed for those who need a helping hand with some of the basics, but don't want to ask those questions of their lecturer. So we're going to use a hypothetical scenario that I've created called FOP Construction's case scenario. And in this question, we've been given who the plaintiff is. However, if in this case scenario, it simply said, FOP Constructions is a registered builder. On or about the 18th of February, it entered into a domestic building contract with Miss Smith, the building contract, pursuant to which FOP Constructions agreed to construct 3 two-story units at 4 Esplanade Road, Glenelg. Ms. Smith is the registered proprietor of the property. So in that first small paragraph, we've been given quite a lot of key information. So we know who the plaintiff is because we've been given it by the lecturer. We have some key dates, but here it's also worthy noting on or about. So if it just said on the 18th of February, that would be fine, but it says on or about. Now that might just be a way of writing and it doesn't mean anything. However, often if a lecturer includes a fact or a specific type of wording in their problem question, it's there for a reason. So we might need to be arguing about that later. We're going to highlight on or about just so we don't forget about it. Particularly if this was an exam situation, you're stressing out probably, you're worrying about the clock, highlight anything key so that you can just come back to it, particularly with a long case study like this, where you're not going to want to read it 4 or 5 times throughout your hour or 2-hour exam. Now, we know that we have a domestic building contract. So we know that this is a contract law issue for a domestic building. That's important when it comes to legislation and the type of case law we might want to reference. Then we have Ms. Smith, who is also a key player. And what have they agreed in this contract? Well, we have agreed to construct 3 two-story units at 4 Esplanade Road, Glenelg. So what I'm going to do here, so if this was an online exam, what I would be doing is I would be saving your exam question into a Word document or printing it out and scribbling all over it. If this is a in-person face-to-face exam on your problem question, if you are allowed to draw on it, I'd be highlighting and scribbling all over it. And if not, you would be given some scrap paper or you can request some scrap paper and I'd be scribbling over that. It's important to get your facts and your ideas down. So what we're going to do here is we're just going to write domestic building contract. Who is it between? We have FOP Constructions with we know that they're the plaintiff. We have Ms. Smith. We don't quite know if she is the defendant or not yet, but we could assume, but we're not going to. We're going to read everything first. And what is the contents of the contract? Well, we need to construct 3 times two-story units. Location is 4 Esplanade Road, Glenelg. That road doesn't actually exist, so don't bother looking that up. It's hypothetical. So we've got some facts here, and we know that she is the owner of the property. Cool. Now, what I generally like to do after I have my facts ready, read through the rest of the case study. We then have some affidavits down here. So we've got a Mr. N, we have a Ms. Smith, and we have FOP Constructions. So this is quite a complex case scenario. If it was just the top part here, it wouldn't be so bad. However, we've also then got some facts that we need to contend with. Then what I'm going to do after I've read through that once and taken notes and highlighted key things that I might think are key, I'm actually going to jump to the questions, because You might start riding off on a tangent, but if the lecturer has asked you specific questions, those are the only things that are going to give you marks or grades, and they're the key issues that they would like you to address. So we know that we need to advise your client. Excellent. Well, who is our client? Well, we know we can act on behalf of the plaintiff or the defendant, or we can argue both sides. So if it says both, that means argue both sides. Equally, you could argue for the plaintiff and then provide some defenses that the defendant might come back with. It's important, particularly in law, to showcase that you can think from another person's perspective or the other client's perspective, because you really want to know what the other lawyer might be thinking. So I'm right here going to write, argue both sides. Any defenses or counter arguments. It's just to jog my brain here. And we just want to make sure that we're showing the lecturer, hey, you know what? I know what they might come back with, and I'm prepared for that. Now, we've also got here that we need to state all assumptions made. So we know that there might be gaps in the material, and it is okay to make up some facts here to fill the gap. So if this was a week 10 question, we probably wouldn't get this. However, because it's quite early in the course, we've been told, you know what, you can make some assumptions and you can get a bit creative with your responses. Provided they're reasonable, this is a great way to show some facts that you think might be important, which are missing. Then we're going to have a look at the question. So question 1, what legislation or case law will you use in order to support your case? So here we are looking for the rules in IRAC, aka legislation, case law. So I'm going to write that down. Legislation. Oops. And you know what? We're also going to try and look for some case law if available. Why not go for double points? Let's give it a go. We need to make sure that it's relevant to the case, which means it has to be relevant to either the plaintiff or the defendant. Then, what are the key issues? So the key issues, so question 2, issues, which is the I in IRAC. So what this lecturer is doing is asking us in a different way about IRAC. So question 1 is, what rules will you be using? Question 2 is, what are the key issues? Well, you don't really know what rules you're going to use until you look at the key issues. That's why it's important to read all of the questions first, because if you just list out any single legislation that has anything to do with this or any case, might not actually help you with your case, because your case depends on the key issues. So they're not looking for every issue, key issues. What do you think may have been discussed at the on-site meeting? So here, assumptions will be made here. State them. How could FOP Constructions prove that a contract existed between FOP Constructions and Mr. Marks, but not with the defendant? So here we are looking for evidence. Do we have phone calls, notes from meetings, paperwork? What do we have to prove? So if we're trying to prove something in court, we need evidence. What evidence have we got here? That's what we're going to look for when we've gone through the facts. FOP Construction submits there is a genuine dispute about the amount claimed by the defendant in its statutory demand because the defendant has overcharged for work performed at the site and did not attend for the number of hours claimed on the relevant invoice. So we know there's an invoice, there's some evidence. How could you convince the court this value is correct or incorrect? What evidence may you rely on? So this is a multifaceted question. And what here you need to do is break down the issues in this question. So we believe there's overcharging. We know that they don't think that they attended work for the number of hours claimed. Do we have anything here? Was there any, I'm looking, is there any site notes showing when people signed in or out? And this is why often project managers will have a log, and you have to sign in and sign out every time you come to site. It's a safety consideration, but also great when it comes to claiming invoices. What work has been completed? How does this align with any planning timelines, project timelines we have. Okay, and then how are we going to convince the court? Well, what evidence do we have? So when we go to court, we don't want to be like, he said, she said, not convincing. What do we have that is hard evidence? I'm talking documentation or something which is not subjective. Make sure that you list it, because that's the second part of the question. What evidence may you rely on? What evidence do we have? Concrete. Potentially, you could use the affidavits because they are a legally binding piece of evidence. However, as we'll see in the next question, there are multiple affidavits which contradict themselves. Oh, there's a spelling error there. That should be contradict themselves on key factual items. What impact might this have on the argument? So here we want to talk about impact of multiple conflicting pieces of verbal evidence from a witness/key player. That's all that's really asking. Now, what should the parties have done to prevent this dispute occurring, and what should they do in the future? This is asking you things like, how do we set up good contracts with good invoicing practices? What do we need to do throughout construction to avoid disputes? How do we handle payment claims, and what evidence do we require to approve invoices? So there's quite a lot of questions in this case study. So now that I know roughly what we're being asked to talk about, it's then a great idea to go back through, read all of the case study notes, read the affidavits and go through them slowly, and take notes before compiling your responses. If this was an exam, it's really good if you've got some dot points for each item before you then start writing your final responses. And make sure that you're referring to facts like dates, dollar values, dispute arose. Well, was that a verbal conversation? Was there anyone else on site who heard it? We know the statutory demands. So when we've gone through and highlighted our key items, we want to be referring to those key facts as much as possible when answering our questions. Because if we refer to the facts, it shows we've read and understood the problem question. Now, if we were given this and this wasn't a hypothetical case, say this was a real case and we don't know the plaintiff, we don't know the defendant, what are we looking for if we're asked about a real case and we're given, say, these questions? Well, this is a pretend real case. So this is a sample case study only. This is not a real court case. We would know that we are in the Supreme Court of South Australia, and we know that we have FOP Constructions against Superb Painting. The case would tell us who the plaintiff and the defendant are. We know that we've got Judge Danielle Fopp, and it was held in Adelaide, and we've got the dates and our case citation. Here on the, here on a case on the front page, it will actually tell you what the key issues in the case were that were discussed. So say you were trying to do an IRAC write-up for a case that exists, actually download the case. I know sometimes it's easier to go to websites that say case summary this or case summary that, but here you have the actual citation. You know exactly who the parties are, and they've given you the key issues. Now, you might not be required to discuss all of these key issues, but we've got some sections of legislation which are discussed, and we know what the key issues that the court were discussing are. Now, here they would show what law firms are available, but mainly we want to know who the plaintiff and the defendant are. Sometimes there'll be a table of contents before a case, in which case you can use that to skip to the different issues. So here we go, genuine dispute grounds. Well, responsibility for paying the defendant, that probably comes back to one of these questions. For example, How can they prove that a contract existed between FOP Constructions and Mr. Marks, but not with the defendant? Does that come back to who has to pay who? Then we have contracting parties, hours worked, any defective and incomplete work. So here we have some key issues. We've got the statutory provisions and legal principles that they'll be using, and we have a conclusion from the judge. Now, if we were doing an IRAC issue, we would go through the introduction, find what we're doing. We've got background. Okay, we know they're a registered builder. What does that mean legally? We've got the building contract. We've got the property. We have a lot of information here. Cases can be overwhelming, but if you utilize the issues at the front, know your questions so you know what part of the case you're looking for, and know what plaintiff and defendant you're looking for, can really set you up to make sure that you don't get overwhelmed when you see 22 pages of a case. You don't have to read all 22 pages necessarily for a case study quick tutorial problem, but you need to be able to identify the key issues. So it's a really important skill to learn, and the earlier you start in first year, start reading the actual case, mark them up, highlight. If you don't understand what the judge is saying or what something means, send an email or post something on the forum to your lecturer and they can help explain it to you in layman's terms. Try to avoid just using case summary pages that were written by somebody you don't know on the internet. That doesn't build your legal skills, and it also might be incorrect, which can get you into trouble with your assignment. So I hope this has been helpful. I hope you now have a bit more confidence in how you would answer a case study scenario that's a bit longer or a bit more complex than you would usually have. And I hope that you've learned how to take some notes as you're going through your questions. Thanks.